agent to trust to, both of them, they are the same. No. They are not the same. They are not the same. Yes, they are similar, but they are not the same. And so you, as you did now, you be my agent. You be my trustee. So the same thing, no difference there. They are not the same. Sebi, I'm a law student. I'm the law student here now. I am not a law student again. This one you are arguing with me. Say they want me. I said that they be the same thing. You go do something. You go represent person. They are the same. Agents, trustee, the same. No difference. Why you argue? Agent and trustee are not this. Okay. Oh yeah. Let's ask you, David. Identical twins. Are they truly identical? Because no matter how identical the twins may be, there are certain things that are not the same and can never be the same. What are these things? I'll tell you at the end of today's video. Ladies and gentlemen, my name is yusufsalako, popularly known as Ori David, a 500 level law student of the University of Lagos and founder of the Ori David Consults. If you are new here, I say welcome to you, and you may consider subscribing to our channel by clicking on the subscribe button down below and hitting that notification bell so you get notified whenever I put up new videos. Now, what I said about identical twins not being entirely identical basically reflects the notion that just because two concepts bear out some similar features, or just because two concepts share borderline features, or simply because they are of common origin, does not necessarily mean they are entirely the same, and does not necessarily mean that we cannot bring out distinctions, no matter how subtle they are, from these two concepts. And in today's episode of Law and Language, the two concepts we'll be interrogating is agency and trust. Agency and trust. Why is it necessary for us to consider the grounds of law as far as the relationship of agency is concerned and as far as the relationship of trust is concerned? This is because in commercial relationships, there is a tendency to misconstrue both relationships, where you see that where in law there exists an agency relationship, both parties could actually say it is a trust. Or where it is actually a trusteeship, they say it is an agency relationship. And it is not surprising that this confusion arises, simply because when one considers the origin of the law of agency, you will realize that the law of agency did not develop or evolve as a distinct or distinct or independent aspect of law on its own. The law of agency emerged side by side and also emerged from some other legal relationships. In fact, Maitland has argued that law of agency was developed from the law of trust. Whether this assertion is correct or not is not the subject matter of today's discourse. However, what is clear is that as at the 18th and 19th century, the Court of Chancery actually treated an agent as a trustee. Owing to this historical affinity between these two concepts, it has engendered or created gray areas in such a way that parties do not necessarily know how to bear out the differences between these two relationships. So in today's discourse, we'll consider the similarities that exist between the agency relationship and the trust relationship. Then we'll then consider their differences so that you don't fall into the pit of errors of thinking that agency and trust are entirely the same. So the first similarity is that just as a trustee can pass valid legal title to a third party, that is a bona fide purchaser without notice, thereby affecting the beneficiary's interest, you find that the agent can as well do so. That is, the agent can pass valid legal title to a third party without actually having the actual authority from the principal. I will explain. In trust, you find that the trustee has the legal title. And there are times that the trustee may deal with the trust property in a way that he shouldn't have actually done, like sell the trust property. And then he will sell to someone that is a third party who is a bona fide purchaser without notice. That is, the third party who bought the trust property without having the knowledge that it's actually a trust property. Now, ordinarily, the beneficiary should say, well, you bought something that this man shouldn't have actually sold. So, well, it is your business. As far as this trust property is concerned, there's nothing you can do with it. The law will say no. This person is a bona fide purchaser without notice. The trustee has passed valid legal title, and it will affect the interest of the beneficiary. Take this down to the context of agency, where an agent also does something without actual authority, which means when he acts outside the authority that has been conferred on him, or when there exists no authority at all. There are circumstances where the agent can still pass valid legal title to a third party, and it will affect the legal position of the principal in a way that the principal cannot then say, no, you, the third party and the agent, is your business. I never gave him the authority to act as he did. What the common law does is that the common law uses the doctrines of implied authority and apparent authority. I will enthuse upon this. The doctrine of implied authority says that there are circumstances where the law will imply these authorities. So take, for example, agency created by operation of the law. For example, agency by necessity. In agency by necessity, there are certain things that the agents will do that the principal has not actually given or devolved authority on the agent to do. So take, for example, where you ask your agent to go sell tomatoes and all, and the car broke down while in transit. Tomatoes are perishable goods, and in order to prevent this, the subject matter of this agency relationship from destruction, let's say the agent then, pull over, get another truck to convey the tomatoes and sell. The agent would expect that you would reimburse him. But there is no agreement that he should actually pick up another truck, enter into a contractual agreement with another third party. Now, what we are saying is this. The agent can actually, in that particular circumstance, can affect the legal position of the principal even without actual authority. This would probably become clearer in the context of apparent authority. Apparent authority is an authority that flows from agency created by estoppel. That is agency by estoppel. And how do you create agency by estoppel? Basically, let's say someone has been acting as your agent. You have represented someone, either by words or conduct, as your agent. And this person has been dealing with people, third parties. These third parties, whenever they see this person, they see you because they believe this person is acting for and on behalf of you. And you made them to believe that. Now, you terminate the relationship, the agency relationship between you and the agent. Then you didn't give notice to the people that have dealt with the agent or people that could reasonably deal with the agent on the belief that is still your agent. The agents are aware that you have not informed these people, which means that he knows that these people are not aware that he's no longer your agent. He went ahead to deal with them. Now, having, let's say, transferred property or any form of contractual obligation with these people, you, the principal, cannot now say, well, he's no longer my agent, so whatever you did with him is at your own peril. No, the law will stop you from doing so. Yes, the agent did not have actual authority, but based on apparent authority in that regard, he's still going to pass valid legal title to a third party without your actual authority. And this is what we mean when we say that just as the same way a trustee can pass valid legal title to a bona fide purchaser without notice, thereby affecting the interest of the beneficiary, the agent can as well do so. Another similarity between agency and trust is that the relationship between an agent, the principal and agent is a fiduciary relationship. The same way the trustee also owes fiduciary, is also in a fiduciary relationship with the trust property. And what this means is that when we look at the case of Parker versus McKenna, it says that the agent cannot act in such a way or conduct himself in such a way whereby his interest will conflict with the interest of the principal. Remember that the agent is a representative of the principal. The agent is rendering service for the principal, either to enter into contractual agreement with the third party or for disposition of property. But remember that the agent is never in business for himself or for his own benefits. So the law is trite that an agent cannot make secret profits without the consent of the principal. He must inform the principal. This is the same way that you hear the court in the case of Foley versus Hill saying that the trustee cannot also make secret profits out of the trust property because there exists a fiduciary relationship. He owes a fiduciary duty to the beneficiary and the trust property. This is the same way the agent owes a fiduciary relationship to, or fiduciary duty to the principal. So no conflict of interest in both relationships. Then the last similarity is that just as there are some available equitable remedies that the principal that the beneficiary may pursue against the trustee, the same way there are some equitable remedies that the principal may pursue against the agent in terms of the principal's property that is in possession of the agent. So, take for example, any agent who makes a secret profit, the principal can bring an action to basically get the secret profits. Another example is this, where the principal's property is now mixed with the agent's property. The principal may also bring an action through the doctrine of tracing and following. This is the same way that where the trustee's property is mixed with the beneficiary's property, the beneficiary can also do the same. In fact, you find that there is a circumstance, a special and unique circumstance, where the agent is treated as a trustee for the principal. This is what is basically known as a constructive trust. So take for example where the agent has made secret profits. Now, you have made secret profit, the law is right that you are not the owner of that profit, of that money. You are going to only be holding it in trust for the principal. So these are the similarities between agency, the law of agency, and the law of trust. And let me quickly point out that with regard to apparent authority, you can check out these cases. You can check out the case of Boardman and Phoebes. In Boardman and Phoebes, the wife was acting as the agent of the husband. The husband represented her to be his agent. Later on, he terminated the agent's relationship but did not inform the third parties. The wife went ahead to contract with those ones, and the court said it's stopped from saying that no, she's no longer his agent. So that's Boardman and Phoebes. You can see a classic case in Freeman Lockyer versus Buckhurst Park. This one also relates to companies, because companies would always enter into contractual relationship through agents. And you can see the case of Pickering versus Busk. All these on apparent authority. So without wasting our time, let us look at the differences that exist, or that bear out the distinctions that bear out between agency and trust. First, you must understand that the trustee is usually invested with a legal title, but the agent is never with the title. Title means ownership, and it's who owns the property. The agent may be in possession, and in most circumstances is always in possession of the principal's property, but he doesn't own the property. He doesn't have a title in the property. The only thing he has is the power to deal with the property in a way that the principal has directed that he should do. But when it comes to the trust, in the eyes of the law, the trustee has the legal title. He has the legal interest. the beneficiary only has an equitable interest. So, which tells you that the title is invested in the trustee, but title is not invested in the agent. Another difference is that we find that the trustees, the duties of the trustees are basically, they are bound by various duties that are found in statutes. Let's say the Trustee Act of 1925 or the trustee laws. But when you look at the duties of an agent, they are not usually, enshrined in the statutes. Majority of them are basically decisions of the courts. However, there is an exception to this also. That is, there is a circumstance where the duties of the agents may also be circumscribed in a statute. This is where it involves corrupt acts, fraudulent acts, bribery and corruption, so to say. So, for example, when you look at the Prevention of Corruption Act of 1906 and 1916, it imposes criminal liability on the part of corrupt agents. But aside this, generally, the duties of the agents are basically not reduced into writing in a statute. Another difference is that consent is usually very key to the creation of agency. I need to state clearly that this does not mean, or I am not suggesting, that consent is the basis of the creation of agency. We've argued that, and I've already shown how consent cannot always be the basis. But what we are saying is that you find that generally there is always a form of consent or agreement between the principal and the agent when creating an agency relationship. In fact, as argued by the learned writer G.H.L. Friedman, he said even where there is no consensual consent or agreement, in the sense that both parties do not necessarily agree, you find that at least one person is agreeing, usually the agent. Take for example, the example I made earlier on with regard to agency by necessity, that is agency by operation of the law. The man or the agent that's contracted with the third party to use his truck to convey the tomatoes has actually agreed to that extent that there should be an agency relationship between him and the principal. Take that of agency by estoppel, that is apparent authority. The rogue that is no longer the agent, but yet parading himself as the agent, has also agreed. So there is at least always the consent of one person. But take it back to trust. In trust, most of the times, a trust is created without the consent of the beneficiary. So, the father may transfer property to your uncle, to Andrew, on behalf of you, the 2-year-old baby. Now, okay, handle this property when she has attained majority age, or probably after a call to bar, then you can hand over this property. You, the 2-year-old baby rather, you don't even know anything about the creation of any trust. So we tells you that consent is not fundamental to the creation of a trust. In fact, in a special and unique circumstance, a trust can also be created without the consent of the trustee. A trust can also be created without the consent of the trustee, because it is the law that is basically creating that content, that trust. This is what is known as constructive trust. You are not, you the trustee, you are in possession of it, and the court is saying, you, that property that you are in possession of, you are holding it in trust, despite the fact that there is no consent to create that trust. Another difference is that you find that the relationship of principal and agent can be created without any special form. Special form like, let's say, to put it down into writing. No. You can create an agent. In fact, in most circumstances, agency relationships are created without necessarily putting it down in writing. But as for a trust, there are certain trusts that must be, when you are to create them, you must put them in writing. An example is secret trust. When you want to create a secret trust, the law is clear that it must be in writing. You cannot create a secret trust without it being in writing. Then the last difference is that why the agent represents the principal, and thus can involve the principal in liability that arises from the Agents Act, this liability can even arise from the commission of tort. You find out that the trustee is not representing the beneficiary. I repeat, the trustee is not representing the beneficiary. And as such, the trustee cannot involve the beneficiary in personal responsibility for the trustee's act, whether in contract or in tort. These differences show clearly that just because the law of agency and the law of trust share boundaries, have similar historical background, or they have cognate historical background, it doesn't mean that they are entirely the same. They are similar, but they are two distinct, different provinces, precincts, and compartments of law, each having its own principles, rules, and corpus of laws guiding it. And so from today, you must always understand that there's a difference between agency and trust. When you want to consider the affinity that exists, the similarity that exists between the law of agency and the law of trust, think of what I said about the twins. They are identical twins, no doubt. But the fact that they are identical does not mean that they are the same. Some things will be different. Their idiosyncrasies may be different. That is, their attitudes, their behavior, the kind of person and personality they have may be different. And even where this is even the same, you find out that the iris in their eyes can never be the same. And more importantly, their fingerprints can never be the same. This is the same way that agency and trust shares similar boundaries, but yet are two autonomous, independent principles of law. I remain yusufsalako, popularly known as, and do not forget to join our 5-day series with reading on the effect of the first mature clauses. Today's discussion takes place on Twitter. Do join us. Check it.